under section 390. Now, there are three issues not raised. Issue number one, question number one, you have to kindly consider whether the trial court has power under 319 CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of the conviction has been rendered on the same date before pronouncing the summoning order. So the question says, well, summoning order came later, acquittal order came first. So after the acquittal of the accused who are already facing trial, whether the summoning order can be issued subsequently when there was no proceeding pending. This has been answered in Hardeep Singh, therefore the question can be very simply answered that Hardeep Singh covers it. Hardeep Singh says, power under section 319 can be exercised after taking cognizance, not before, and until judgment is pronounced. Hardeep Singh says, so here judgment has been pronounced, and after judgment has been pronounced, as per Hardeep Singh, new order can be made in section 319. So this can the question can be very simply answered in that way. The question is whether in this given case, the 319 order was passed when the proceeding was pending or after a termination, a question of fact, which cannot be gone into by this order because it is my humble submission. This is to be gone only by that court where the matter is actually pending. But the question is, there was one question interestingly raised as to when the proceeding gets terminated. The argument is as soon as the arguments are over, as per section 353, the trial gets terminated. And therefore, if any order is made in section 319, after the arguments are over and before judgment is delivered, that itself is...
No, that is not Mr. Patel's argument. No.
That is the argument.
No. He says that once the judgment is pronounced, then the court becomes hon'ble officio. He also agreed that in the event the evidence is complete, the matter is argued, the judge goes through the papers and before the pronouncement of the judgment, he finds that there is some material against the proposed accused, then at that stage of power can be exercised. Have we understood properly?
Because then the trial will be reopened. Necessarily the trial will be reopened.
In the referral order, yesterday he referred to section 353 to say that the trial is over, the trial is over, the moment arguments are, that was in the referral order also says the same.
Yes.
The referral order also says the same.
The trial is over the moment the matter is kept for orders. When the judge says arguments concluded, judgment reserved, trial is over. That's one part of it. That's the CRPC is clear. Then the observation came. What happens if the trial is over but judgment has not been pronounced, and he finds that there are some people who needs to be arraigned? Is he powerless? My submission is no, he is not powerless. He is not powerless because then he can reopen the trial because then it is still within his strength.
Once the judgment is pronounced,
then it is correct. So if the trial is over, but he is still in session because he has power to reopen the trial.
After the trial is over, he examines the evidence. He considers the argument.
Correct.
And at that stage, he finds that no, somebody has to be proceeded further.
Then he will reopen the trial and then pass an order and continue.
That is a suo motu under 390.
Yes.
He can always. That is an inherent with every judge who is dealing with the case.
In the referral order, you will have to kindly see there was an argument advanced. That is, one case is kept for judgment, then after that there is no power.
But then he has fairly, even now he is...
If he concedes, we got no difficulty. If he concedes. So this is regarding question number one. Therefore, in my written submission, I report to section 232, 235, also to say that the proceeding gets terminated on the pronouncement of judgment. But if it is a case of conviction, not even by the pronouncement of judgment or conviction, until sentence is imposed. Yes. Because proceeding continues. Evidence can be let in respect of the question of sentence. Accused is to be heard. So until sentence is imposed on the accused, proceeding is pending before the said court. That law has been laid down by 3-judge bench of this honorable court in 1995, 2 SCC page 513, Ram Naran case, paragraph 12. They very elaborately dealt with the same. 1995, 2 SCC 513, paragraph 12. So this is on the proposition, Murad, that...
Have you referred to in this chart judgment Ram Naran? No.
Ram Naran is not referred.
What is that judgment?
1995, 2 SCC page 513, paragraph 18, 12, paragraph 12. But 12 and 30.
25 to SCP.
Page number 513. Not a judgment. That's the point. What we really can do paragraph 12. Paragraph 12 minutes. Page 523. Chapter 18 relates to trial before a court of session. Section 225 to 220 relate to stage prior to the framing of charge. Section 228 provides for a framing of charge against the accused person. If after the charge is framed, the accused pleads guilty, Section 229 provides that the judge shall record a plea and may in his discretion convict him thereon. However, if he does not enter a plea of guilty, Section 230 and 231 provide for needing of prosecution evidence. If on the completion of the prosecution evidence and examination of the accused, the judge considers that there is no evidence that the accused committed the offence with which he is charged, the judge shall record an order of acquittal. This is 232. Seldom it is used by the trial courts nowadays. 232. When all the witnesses turn hostile, there is no need to put questions under 313 or to call upon the defense to examine any witness. Straight away the accused can be acquitted. The distinction is this is an order of acquittal, not judgment of acquittal. It's an order. 232. The court shall record an order and simply acquit by writing in one line that there is no evidence. So, if this is 232, if on the completion of the prosecution evidence,
There is nothing for 313. No? There is nothing for everybody.
there is no incriminating evidence,
Nothing.
no giving a benefit of doubt, simply acquittal. This is by means of an order. The distinction is under section 232, it is an order of acquittal. Whereas under section 235, it is a judgment of acquittal. Judgment should contain all the details as are prescribed in section 353 and onwards. Last title, issue, so many things are prescribed in section 353. The 354 language and the contents of judgment, except as always expressly provided by this code, every judgment, not an order, every judgment reported in section 353 shall be written in the language of the court, shall contain the point or point for consideration, the decision thereon and reason for decision, shall specify the offence of which and the section of the Indian Penal Code or other law under which the accused is convicted and the punishment to which he is sentenced. If it is to be judgment of acquittal, shall state the offence of which the accused is acquitted and direct that he be set at liberty. When the conviction is under section of the Indian Penal Code and it is doubtful under which of the two, it goes like that. So this provision section 354 is not applicable to section 232. It is an order, it's not a judgment. There is a vast difference between these two. Now, reverting back to the judgment in Ram Naram, paragraph 12, middle, the accused would have to be called upon to enter. If the judge does not record an acquittal under section 232, the accused would have to be called upon to enter on the defense as recorded by section 233. After the evidence in defense is completed and the argument heard as recorded by section 234, section 235 requires the judge to give a judgment in the case. If the accused is convicted, subsection 2 of section 235 requires the judge shall, unless he proceeds in accordance with the provisions of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. It will thus be seen that under the code, after the conviction is recorded, section 235(2) inter alia provides that the judge shall hear the accused on the question of sentence and then pass sentence on him according to law. The trial therefore comes to an end only after the sentence is awarded to the convicted person.
Yes.
Perfect.
So therefore, Murats and
Nagamuthu, section 232, does it use the word order or judgment?
order,
Order of acquittal.
order of acquittal. What really have you looked into?
Because a judgment was.
If after taking the evidence for prosecution, examining the accused and hearing the prosecution and the defense on that point, the judge considers that there is no evidence, in that the accused committed the offense, the judge shall record an order of court. not a judgment. Therefore, 353, 354 not applicable. 313 questioning is not there because there is no incriminating evidence. Straight away, by single line, the court can say that there is no evidence. Therefore, I am recording an order, acquitting him. That is enough.
For how many decades this provision has not been exercised?
In some judgment, in our High Court, we highlighted this. And we also told the judges in the Judicial Academy, but
They're scared,
it is strictly followed.
they're scared to use.
Statements.
But it will reduce the time of the court.
We see some of the convictions recorded only on the basis of 161 statements.
Yes, yes. That is also there.
At least I know of cases where 313 statements are not recorded in the person's expectation.
Recorded.
There are some cases, at least in Gujarat, where 313 statement is not recorded, where there's nothing to be asked, and they're acquitted. But these 232 provisions are followed in, at least in Gujarat. I don't know about Tamil Nadu, but
It is not followed.
At least in Maharashtra, it is not followed.
Followed. Yes,
many
yes.
cases, there's so many cases, those cases don't come up, my lord.
They are acquitted before 3:30.
Actually, you can.
If there's no evidence.
Time if they apply all.
Yes, we can save the
Those
time.
cases don't come up to the High
You
Court.
can save time, but you can't save the judicial officer then.
That is
Yes,
also a
yes.
problem.
So that is what I intended to say, but I thought that it was not appropriate for me to say this before this honorable court.
They are
But
They are
they take a different view, and they may issue memo calling him upon to explain that why you have not written a judgment. That is why they are afraid. But therefore, I would request this honorable court not to declare that this procedure can be strictly followed. Because statutorily it is permissible for them. They are afraid of reeling. They are afraid of reeling. That's even in respect of the honest court case, your lordship knows more that when there is no material available to remand the accused, but the magistrates still, even today, they remand. They do not want to run the risk as it was pointed out by Honorable Justice VRSP. They do not want to run the risk. That's a problem. So therefore,
If all of them follow all this,
Yeah.
then all of us will be running out of business.
We also alert.
as it may be.
We also alert.
So therefore, my fervent request would be, at least in this case, we will also kindly declare that section 232 may be used in appropriate cases by the courts.
But that is not a point for reference. Again, you will
Yes,
find
yes.
with us.
There may be an case, an observation made by the honorable court. So
Yes.
therefore, my humble submission so far.
There is evidence, it is not using it.
Therefore, in a nutshell, the trial comes to an end only upon sentence,
Sentence or acquittal.
acquittal.
Or acquittal. Until the trial goes on, until then the court has got power under 319,
Even if it is reserved for judgment, still the presumption is trial is going on.
trial is going on. Because not on conviction, the accused is to be heard and the accused has got right to lead evidence. Under 235 too, he has got power, right to lead evidence. So therefore, my humble submission, we have been held by the three judges. Trial gets over, but sentence is important until then.
Even if the judgment is reserved, still there is an opportunity to open the,
Open it.
reopen the case.
Then 311 can be filed by the accused at any stage.
What provision?
311 can be filed at any stage. Like civil case, there is no provision here to reopen at all. In CPC, there is a provision to reopen after the case is reserved for judgment.
Yes.
But in CRPC, there is no such provision in the court to reopen. There is no need, necessity. But the accused can very well file an application under section 311 at any stage of the trial before judgment is pronounced. And there is no question of reopening. Question is whether to allow the petition or not.
That's different, that's different.
Yes.
That is on the merits of the.
Merits. So there is no question of reopening. Yes, 311.
Says inquiry, trial or other proceeding.
Pending. Any court may, at any stage of any inquiry or trial or other proceeding, under this code, summon any person as a witness or examine any person in attendance, do not summon as a witness or recall or re-examine any person already examined. The court shall summon and examine or recall and re-examine any such person which evidence appears to be essential to the just decision of the case. When the matter is under consideration for preparing judgment, the court finds that some important witnesses have been omitted. So motor court can do under 311. There is no question of reopening. The suo motu power of the court under second part of section 311 gives suo motu power and it compels the court also. So therefore, so far,
So after the judgment is reserved,
yes,
now after going through all the materials, the magistrate may feel he wants to summon somebody.
yes, he can,
311.
he has to, not only he can, Murad. There is an obligation on his part to summon. Second part, first part, Murad, discretion of 311. So for a second part is concerned, it is obligation, it is necessary. Let me kindly have a look at. Any court may, first part. At any stage of any inquiry, trial or other proceedings under this court, summon any person as a witness or examine any person in attendance. Do not summon as a witness or recall and re-examine any person already examined. This is the first part. Then second part, and the court shall summon. Second part, the court shall summon and examine or recall and re-examine any such person if his evidence appeared to it to be essential to the justification of the case. A witness already examined can be recalled. A witness who was not examined can be summoned afresh.
At this stage, he can even issue 319 also. Why not?
Yes, based on that evidence.
Based on that.
Based on that,
Or whatever. Yes.
based on that evidence. He can summon somebody, he can examine, promote his evidence if he finds that some person has been omitted, who should also be tried along with these people. Then he can be summoned based on that evidence. So therefore, in conclusion, my submission would be that trial gets over the moment judgment of either acquittal or imposing sentence is until then 319 can be.
So you also agree with Mr. Patwalia that once the sentence is imposed,
Yes,
Yes.
319 cannot be invoked.
yes. Yes, Mother. So it's a question of fact. In the given case, it's a question of fact. Whether sentence was imposed.
So no, the question, one of the questions posed is the same question.
Yes.
Whether after pronouncement of judgment,
After
whether 319 could be invoked or not.
Brother Hardeep Singh itself says that after pronouncement of judgment, the power under 319 is not available.
Typically, that is said in para 47, but not in the concluding paragraph.
Then, Murad, we move to the second question, Murad. The second question is whether the trial court has power under 319 CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing, pending, having been bifurcated from the main trial. But my answer is, it was also argued by him.
It is more an academic, not arising out of the facts of this case, perhaps.
Yes, ma'am. Being academic minutes, the answer would be, my humble submission would be, but the evidence recorded in a particular case is to be taken into account, not in some other case. If my lord was also pleased to pose a question to him yesterday, whether such a petition of 319 is filed in the split up case, what will you do?
Yes.
Then he fairly considers that he has to face.
Yes.
So the evidence recorded in a particular case alone can be taken into account, not the evidence either recorded or to be recorded in future can be taken into account.
Yes.
So in this case, Murad, the evidence already recorded.
Except under section 45 or 145 of the Evidence Act. What is that?
That is for the purpose of contradiction. Now, Murad, I will come to the later. Now, Murad, what is the evidence to be considered? Murad, the evidence which has been recorded already in this given case.
What you are suggesting is,
Yes.
in the, let us assume, and there is an absconded, yes, absconding case.
Yes.
In that case, material should come to summon a person under 319.
Yes, in
Fresh
that
material.
case.
Not
Where-
in this case, concluded case.
This evidence cannot be used in that case, Murad.
Yes, you are.
Because under section 273 CRPC, evidence means evidence recorded in the very presence of the accused.
Yes,
Here, Murad, the absconding accused is not present here.
yes,
Therefore, the evidence recorded in this case is no evidence in that case.
yes,
In that case, all the witnesses are to be examined afresh in civil examination.
yes.
And cross-examination also. In that case, Murad, if it turns out that these people are also involved, based on that evidence, Murad, not on the 161 statement, not on the FIR,
Yes,
based on that evidence recorded in that case,
yes.
he can be summoned. Not based on the evidence recorded in some other case.
Even Nagamuthu, in reality, all the witnesses must have been fully trained, no? When they go to the second trial.
There is a danger also.
Unless the opposite side wins, you know.
Murad, that is why, Murad, the evidence recorded already can be used as a previous statement to contradict.
Yes.
It can be used for corroboration. It can be used for contradiction. Murad, 145, Murad, 157,
Section
Murad, it's a
145
corroboration.
confronted.
But this evidence cannot be, previous evidence cannot be used for corroboration because there are two conditions laid down in section 157. 157 says not any former statement, not previous statement. Any former statement given to a person legally competent to investigate. That statement can be used, Your Honor, kindly see the language I will read. In order to corroborate the testimony of a witness, any former statement made by such witness related to the same fact, at or about the time when the fact took place, or before any authority legally competent to investigate. Here, the trial court is not investigating. Therefore, the evidence recorded already would not fall under section 157. Therefore, the prosecution cannot use that statement record in this case, in the future case, for any purpose.
Or to the limited extent and on 145 for to contradict.
That is by the accused.
That's all.
That is
By the accused. Yeah.
If he turns hostile by the prosecution. 145 does not put these two conditions.
Yes.
145 is very plain in language. It says any previous statement can be used to contradict the maker when he is examined as a witness in a subsequent proceeding. Here, Murad, these statements recorded in the first case are all former statements, which would squarely fall under section 145, which can be used by the accused or the prosecution to only to contradict.
And why do you draw this contradiction only to test the creditworthiness of that fellow? Is it?
Yes, yes.
For a limited extent.
Yes.
Whether that fellow is dependable or not.
Section 155, Murad. Section 155, how to impeach the credibility of a witness. One of the ways Murad used to prove by proving the former contradictory statement. 155.
It's a contradiction.
Impeaching credit of a particular witness. The credit of a witness may be impeached in the following ways by the adverse party or with the consent of the court by the party who calls him. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. So I am contradicting under 145. I prove the contradictory earlier statement. Therefore, the credibility of the witness is impeached under section 155. For that purpose, the accused can use it, not for any other purpose.
Only if he resiles from that.
No, but that will
If he's saying something contradictory to what he has said in the
Yes.
earlier trial.
For 140, I need not go into it, it will take some more time. How to contradict, I need not go into that part in this.
That's all right, that record, you know.
I'm not
You
going
know
to-
that.
There are two parts in section
Yes.
145.
Those who have practiced in the trial court know all these things. Not directly who come to Supreme Court.
Don't lay down the law.
25 years of experience in the trial court.
Yes.
Little I know. Sorry.
No, in this case, already an application has been filed and this order has been passed, which is a subject matter now. Now there is another trial which is going on.
No, not.
Now, in that trial, if the evidence comes up, is there a bar to file a similar application?
Similar application can be filed there.
Can be filed.
That is a different evidence.
Provided that evidence
That
comes,
different set of evidence.
that evidence,
Fresh.
It can be.
Evidence should come afresh in that
I
case.
agree with that.
can,
It can be.
so that can,
Somewhere that is in respect of second question. But third question,
Mr. Nagamuthu remembers all my concessions very clearly.
Patwalia, trial court practice should be made mandatory for all the lawyers, not very directly government coming here. And taking some interim order and walking away.
honorable judges have the rich trial experience. Sitting in this bench, one of the honorable judges I know has got rich trial side experience, but on the civil side.
But trial side does not get you money. That is why we land up here.
Yes, Murad. Regarding third question, both the sides said that Hardeep Singh is very comprehensive and therefore further guidelines are not required.
Yeah.
Murad, at least on two issues, Murad, there may be some addition. Number one, Murad. Question is, Shashikant Singh case, Murad, we say, question also arose yesterday. Suppose the accused is addicted, trial is pending, 100 witnesses have already been examined. Now, at that stage, Murad, one accused is added under section 319. Now, whether de novo trial is to be conducted in respect of all the accused, in which case the evidence already recorded will not be, cannot be considered. Fresh evidence is to be recorded. Those 100 witnesses are to be examined afresh. It will be laborious, it will be unfair, my lord, so far as the existing accused are concerned. To ask them to face the trial again, to cross-examine the witness again, all these things. So, but practically what is happening, my lord, in this country? My lord, whenever an accused is added, he is tried jointly, necessarily and compulsorily with the existing accused. That is why this problem arose. Yesterday, my lord was also pleased to ask me what will happen to the earlier evidence. The section 319 says that de novo trial so far that person is concerned,
Such persons.
which means not the newly added person. Therefore, my senior friend was referring to section 317, which says that you can split up the case. 370, with great respect, 370 won't come at this stage at all. What is the relevant provision of 223? You not may kindly consider 223.
Yes, 223.
Right, yes. What person may be jointly, may be charged jointly? The following person may be charged and tried together. Not my kindly convince. Charged and tried together. Namely, persons accused of same offence committed in the course of the same transaction, persons accused of an offence and persons accused of abatement or attempt to commit such offence, persons accused of more than one offence of the same kind within the meaning of section 219, then formula D. Persons accused of different offences committed in the course of the same transaction. But the court has got discretion to have a joint trial of all these accused who fall under any one of these categories. But it is not mandatory that there has to be a joint trial in every case. It is a discretion of the court. For the sake of convenience, this discretion is used to have joint trial in every case. The accused has got no right to demand for a joint trial in any case. It is a discretion of the court. Suppose, under section 319, one accused is added. The court has to, at that stage, decide whether he should be tried jointly as per this provision along with the rest of the accused or not. He has to decide. If he decides, yes, it is better that he be tried jointly along with other accused, then, my lord, this problem will arise. All the witnesses are to be examined afresh. Suppose the learned judge decides, no, it is not necessary. He can be tried separately as per section 223. He will be tried separately because 223 is an exception to section 218.
About 372, 317.
Yes, I will come to that point. Therefore, under this provision, at that stage, court has to decide whether to have a joint trial or separate trial. If the court decides to have separate trial, then, my lords, de novo trial, fresh trial will begin only against this person who is added as accused on 319, not against all. So ultimately, my lord, there will be two trials. One against one set of people, the other against the newly added person. Two trials will be there. In the former case, there can be a judgment delivered separately, and in the subsequent case, my lord, because after 319, charges are to be framed against him, evidence is to be recorded. The evidence already recorded in the earlier case is no evidence in this case. Because under 273, you lot may kindly have a look at section 273, my lord.
But we see 3191, it says, could be tried together with the accused.
Who could be tried together. Not to be tried, could be tried, who could be tried together, and he may be tried separately also. Language used to be not make kindly.
Nagamuthu, tell us one situation.
Yes.
Now take a case where before the judgment is pronounced, an application is made either suo motu
Yes.
or at the instance of somebody.
Yes.
Before the pronouncement of the judgment.
Yes.
Now trial is complete.
Yes.
Now what should he do? The magistrate has.
So 319 used to be allowed.
Ah.
On allowing that, he has to pass an order directing separate trial against that person alone.
Now till the trial is completed, the judgment has to await, is it? The other judgment?
Until 319 order is passed, he has to wait for without pronouncing judgment.
No, 319 order not, after a trial on a, against this person, then simultaneously judge.
No, not necessary. Because separate evidence, fresh evidence is going to be recorded in the subsequent case.
Yes.
It is only on analyzing the evidence to be recorded in the fresh case, the new case,
Yes.
judgment can be given.
But in the meantime, can he pronounce this judgment?
Yes, there is no bar.
But then Patwale has no case then.
There can't be. The reason is this, you will not be kindly consider. There are 10 accused in a given case. 2 people are absconding. 8 people are tried. The case against 2 people are separately kept. But they are split up, separately kept. But can we wait for the trial of those two cases to get completed without pronouncing judgment of first case? First case judgment can be pronounced. The second case will begin later. Trial will go on and there will be separation. But only one thing is, the same judge cannot try because he already made up his mind. He cannot try. The case has to go before some other judge. He will try the case. That's the only thing. So, my humble submission would be, under 223, the court has to decide whether to have a joint trial at that stage. If the court decides not to have a joint trial, there will be a fresh trial against the newly added accused. Insofar as others are concerned, judgment can be pronounced based on that.
Allowed earlier.
Yes,
Correct.
earlier.
Ah,
Earlier.
It doesn't go against Patwali.
Yes,
Doesn't
no,
go
that
against
is a
the
question.
application.
That is why I did not go into that, whether the order was passed before pronouncement or
No,
after.
that is, there is injury allowed.
It's a question of fact.
Then say that it will be a separate trial and then pronounce the judgment.
But 319 used to be allowed when the trial is pending. At that stage, when the accused has to be summoned, he will appear. The court has to comply with section 207, supply the copies, and thereafter, court has to frame charge, whether jointly or separately. At that stage, court has to decide. It is only after compliance of 207. All these things must happen when the trial is pending. When the trial is pending, 319 is to be filed. When the trial is pending, 319 is to be allowed. When the trial is pending, accused is to be summoned. When the trial is pending, copy is to be furnished to him under 207. Then at that stage, Posina framing charge comes under 223. Under 223, at that stage, what has to decide?
But in this
What
case,
has to decide whether he should be jointly charged or separately charged? 223.
Muthu, please come at 2. We have to raise a bit early.
Grateful.
But we may have to ask you a few questions.
Grateful. Grateful.
What he's saying actually supports me. That it says this order has to be.
You are right. You are right. Because the application has to be allowed first.
First, that is
Thereafter, he can, because he is right, independent evidence has to be let in so far as that accused is.
thereafter he decides whether he wants to have a joint trial or a separate trial.
Yeah, you are right. You are right.
in this case, but in this case, all that happened on the same date.
Yes, sir. That is
After the judgment was
that is on question of fact, that is to be decided by the other court, not by the Supreme Court.
Nagamuthu, supposing an application is allowed before pronouncement of the judgment, let us
Yes.
assume,
Yes.
then he has the discretion to scrap the entire evidence and try together, or he can independently try this person.
Yes, it is
Correct.
for the judge to decide.
No, he has the option, this or that, depending on the facts of the case.
No, option is for the court, not for the accused.
Yes, yes.
Court, for the court. Accused cannot demand that I should be tried with this man or I should be tried with the other man.
This is what is happening every day. They say transfer this case from this side.
Cannot make a demand.
Even the CBI says don't transfer.
No,
this
the
case.
proviso to 223, it gives a, he can make a request and court may consider even in cases which are not connected.
Yes, accused has to make
Even the accused
make a
can.
request,
Proviso.
but he cannot make a demand.
You can't.
He can only make a request. That is, in respect of some other case also, he can make a demand. He make a request. Suppose, I am an accused in 3 theft cases. Only one case is pending before this court. I can request the court, to bring those 2 cases here to have a joint trial. That is permissible under section 223. That need not be there. It need not be that all the offences are in the same transaction. 3 different transactions, 3 theft. Today one, tomorrow one, day after tomorrow. 3 different occurrences. But still they can be tried together. That is dealt with in section 221.
It should be in 1 year.
221.
It should be in 1 year.
So the accused has got right only to make a request. Please try all together. That is the only request he can make. But it is the discretion of the court at what stage the petition is to be filed and what stage the order is to be made. Sir, I made it very clear. That petition is to be filed when the trial is pending. That is until judgment of the acquittal or sentence is imposed. 2, order should also be passed when the trial is pending. The reason is that thereafter, after the order is passed, the accused is to be summoned. He will appear. 207 is to be completed, copies are to be furnished, and thereafter onwards, the court has to decide whether he should be jointly charged along with the existing accused. That occasion comes only at that time. And at that stage, only the court has to decide whether there has to be a joint trial as well. So therefore, all these things should happen not when the already existing accused are still facing the trial, not after that. But the prosecution themselves may at times request the court to have a joint trial. Two illustrations they can give. Suppose, Munoz, the newly added accused have given some kind of confession to somebody. That confession, being a co-accused confession, could be used against others, provided there is a joint trial as per Section 30 of the Evidence Act. If the prosecution wants to have the benefit of the judicial confession given by the newly added accused or some extrajudicial confession, then they themselves will insist for joint trial. So they can justify the request before the court also. One danger also I would submit. There are 10 accused now facing trial. 2 persons now are added on Section 319. One person, after summoning, makes an application to the court that I want to become an approver. He can be made as an approver after giving pardon under Section 307. If he gives a confession, judicial confession with the record on 164, and he is given pardon, either under Section 306 or under Section 307. If it is under 306, under 306 subsection 4, again his statement is to be recorded. That is also an evidence in admissible in evidence. Then, if pardon is given, he will be examined as a witness now in the very same case. If the earlier case is pending, he can very well be examined as an approver in the other case, in which case the others can be convicted based on his evidence, which is corroborated in material particular by other evidences. So in those circumstances, the prosecution themselves may insist that there has to be a joint trial. If the Patti case has been already disposed of, where is the occasion to have a joint trial again? Therefore, my humble submission would be that this joint trial business comes only after summoning the accused and after complying with Section 207 CRPC. It is at that stage court has to decide what to do next. Whether I should join these people with the others and have a trial afresh against all, or I should proceed only against this one separately and proceed against the others as it was and give judgment in that at that stage. So therefore, my humble submission would be, 319 order should be passed when the trial was still pending. It is my humble submission. But in a given case, in this case, I do not want to go into the facts of the case, whether the impugned order under Section 319 was passed when the trial was pending or after the trial was over is a question of fact. That I am respectfully submitting that question need not be gone into this honorable court at all. At what stage this order was passed? This honorable court has been called upon to declare as to what stage, till what stage this order can be passed. Already it has been declared in Hardeep Singh, till judgment is pronounced. Therefore, my first question can be simple. Yes.
According to Hardeep Singh, does not require any reconsideration. That is right.
Yes, yes, that is my humble submission. But one more thing. Now regarding question number 2, the joint trial you said. Then my learned senior counsel was referring to Section 317. The other was also pleased to ask me about that. But 317 does not arise at all in this case for consideration. Your Honor, kindly consider 317 when does it come? It is Section 223 which is relevant. 317, and there is a joint trial. At any stage of an inquiry or trial under this court, if the judge or magistrate is satisfied for reasons to be recorded that the personal appearance of the accused before the court is not necessary in the interest of justice, or that the accused person persistently disturbs the proceedings in court, the judge or magistrate may, if the accused is represented by the pleader, dispense with his attendance and proceed with the inquiry or trial. Now, this is the power of the court to dispense with the personal appearance.
Like 205, like type 205.
205 is permanent measure.
Permanent measure. This is
370 on today,
for the date.
after 10 accused, one is unable to come. We file petition to 370. It is allowed.
90% of the cases, I think 317 is used.
This is a junior's paradise.
Yes, yes.
For every 370 petition, 10 rupees. Peace to the junior.
Those days.
So, so in those days, I'm saying,
The common ground is unavoidable circumstances.
yes, in every.
Type is type now.
So, part 2 was relied on by my friend Munad. Part 2, subsection 2. If the accused in any such case is not represented by a pleader, Munad, in this case, he is represented by a pleader. He is very much present. Or if the judge or magistrate considers his personal attendance necessary, which means Munad, he is not present today. We have to read it along with subsection 1. Then in such an event, there are two options for the court. One, the court may simply adjourn the case, waiting for his presence on the next hearing date, or the court may split up the case. That splitting up will arise only when there is a joint trial. That splitting up is on account of the absence of the accused. That is the reason why it is split up. Now that question doesn't arise in our case at all. Therefore, I would submit, Munad, in our case, what is the appropriate provision is 223. Where Munad court has been given power. That 223 is an exception to section 218. You ought to kindly have a look at 218 for Munad. You ought to kindly consider this. For 218, for every distinct offence of which any person is accused, there shall be a separate charge, and every such charge shall be tried separately. Now, 223 is in the way, it is an exception to section 3, 218. 223 says, Munad, that what persons may be jointly tried, then you will also kindly have a look into 219 onwards. 219, 3 offences of same kind within a year may be charged together. 220, trial of more than one offence in the same trial. Then 221 minutes, where it is doubtful what offence has to be tried, alternative charge. 222, when offence proved included in the, that is not relevant for the present minute. Suppose 326 is the charge, the person is convicted in section 324. One cannot say that there was no charge under section 324. Now 222, then 223 minutes, joining several persons in the same trial by having a joint charge. The following person may be charged and tried together. So this occasion, 223 is appropriate provision. Therefore, I submitted, Munad, this occasion would arise only when the accused appears. Munad, this will arise only at the stage of framing of charge. When the occasion for framing of charge comes, you will kindly consider that 225 onwards, Munad. 225 onwards. Munad, I am referring to the magistrate court warrant procedure, same thing, Munad, therefore I am not referring to that. 225. Munad, 225, in every trial before a court of session, the prosecution shall be conducted by a police prosecutor. 226, opening the case of the prosecution. Then 227, discharge. 228, framing of charge. Munad, it is only at this stage the court has to decide whether there has to be joint charge and joint trial. This can happen only after the appearance of the accused. That may kindly consider it. Maybe argued before this honorable court that 319 order can be passed. Accused can be summoned later. By that time, the first trial need not be pending. That kind of alternate argument is also possible. My humble submission would be, Munad, that argument may not hold water. The reason is simple. So, as I gave two illustrations, he may turn as an approval tomorrow. The newly added person may turn an approval tomorrow. In which case, he will be a witness in the first case. Or else, Munad, the confession given in the first case by some accused, judicial confession, may be used against this man. If he is tried jointly, if he tried separately, Munad, that judicial confession given by one of the accused, existing accused, cannot be used against him. Section 30 is a bar. Therefore, Munad, there may be an occasion where, notwithstanding the hardship that all the witnesses are to be recalled, again that we examined, etc., etc., the court may decide to have a joint trial. But in practice, what is happening, Munad, is I have to confess to this honorable court that no separate trial, to my knowledge, is conducted. In every case, Marat, joint trial. And if the lawyer gives a concession, no, you will not recall all the witnesses, you need not recall all the witnesses. These witnesses are sufficient, I will only cross-examine. This concession is given, that is how it is adjusted, but that is totally illegal. In your section 273, under 273, evidence record must be recorded in his presence, very presence. Because even demeanor of the witness is to be noted down. I should know how the man deposes. Then only I can have an effective cross-examination. It is a fair trial guaranteed in Article 21.
Oh, demeanor will be watched by the advocate. Now, what will this accused do, sitting in some corner behind?
Suppose the accused is doing the case in person.
Suppose?
The accused himself does the case. He cross-examines. He is not engaging a counsel. There are several such cantankerous people. They do it. So in which case, so demeanor is to be seen. And my mentor used to tell me that out of every 100 rupees that is paid to you, rupees 75 is meant to closely watch the chief examination. Rupees 25 goes for your
Actual
cross-examination.
cross-examination.
Yes.
75 rupees is for what? To decide.
Closely watching the chief examination. Demeanor. Closely watching. So from out of that, we get lot of clues to cross-examine.
Watching.
So therefore, the evidence recorded in his presence is evidence. The evidence recorded in his absence is no evidence at all. Statutory provision is there. 273. CRPC. Will not may kindly have a look at 273. Will not may kindly pardon me. I'm not taking much time. I'll close it. Yes. Except as otherwise expressly provided. Well, this is under section 317 I read by dispensing his presence. Except as expressly provided, all evidence taken in the course of trial or other proceeding shall be taken in the presence of the accused. Shall be. Or when his personal attendance is dispensed with in the presence of his pleader. That is not, as my lord was pleased to point out, either 205 or 317. So, it happens in some trials. Suppose the accused do not want a trial to happen today. The accused will abscond.
No,
It happens.
that is mostly in the advice of the defense counsel. Someday you know.
It happens.
That your mentor did not tell you. I know that.
Generally,
Yes, sir.
317 application is not allowed when the witness is being examined. Generally, whether it is allowed.
It is allowed, but if it is not allowed, a witness cannot be examined. If 317 is allowed, then personal attendance of the accused is dispensed with, lawyer is present, witness can be examined.
What is the significance of 205?
205 in someone's case, it is a permanent measure. Petty cases, small, very small cases. Not 205 is not applicable to section cases. Very small cases, from Factory Act case, from Prosecution of Factories Act. So
Even
normally they find
Motor Vehicles Act.
small
Company
cases.
Companies Act.
You can even without the lawyer, you can just.
Companies Act, fine is.
Factories Act, small matters. 205 is paid. And that is not applicable to section cases. Here it is only 317. For every hearing, we have to file petition of 317. So 317 is applicable only during the trial when there is a joint trial. Now, there is a provision, that provision enables the court to split up. Watch it, because he is absent. There is no petition to 317. Therefore, at that stage, the court can split up the case and keep this case separately and proceed against the others. That occasion doesn't come in our case at all. Here we are yet to decide whether there is going to be a joint trial or separate trial. That is the discretion of the court. Then, my lords, Shashikant Singh case, it is a two-judge bench judgment that my senior has also referred to. There, my lord, the point which I have been arguing all along, my lord, is reiterated. It is declared that whether it is going to be a joint trial or separate trial is the wisdom of the court. That is held in that judgment, my lord. This judgment, has been slightly doubted in the referral order. This judgment, I have given the list, has been followed, in at least 10 cases.
Shashikant.
Shashikant has been followed in 10 cases. I have given the list of all the 10 cases. But all two judgments in 10 cases.
But then that view appears to be prima facie correct. Because 319 of section 1
Yes.
is for arriving at the subjective satisfaction of the court.
Yes.
Whether a particular person can be proceeded further with or not.
Yes.
If you read it, where in the course of any inquiry into or trial of an office,
Yes.
it appears from evidence
Yes.
that any person not being the accused
Yes.
has committed any offence
Yes.
for which such person could be tried together with the accused.
Yes.
The court may proceed against such person for the offence which he appears to have committed.
Could be tried.
Could be. So the subjective satisfaction is whether there is a material
Yes, that is.
that a person to be brought to the court could be tried jointly with other person.
Yes.
And then thereafter, there is nothing which prevents to hold a separate trial against it.
That comes only under
Under 4.
223.
319.
But 319 doesn't say that necessarily the accused is to be tried jointly. It says it could be tried jointly, which means it can also be, he can also be tried separately. But to decide whether there has to be a joint trial or not is the wisdom of the court under 223. Right? That 223 is to be applied not only under when the question of charge framing arises. That will come not only under section 228. Only at that stage, court is considered whether the accused is to be jointly charged or not. Because 223 says when persons can be jointly charged and tried. That occasion comes only at 228 stage. So until then, the first case is to be kept pending until a decision is taken. That is my humble submission. But so far as Sasikant is concerned, at least in 10 cases they given, in all these 10 cases, Sasikant has been followed and it has been well settled that whether in a given case joint trial or separate trial,
They are also only referred, nothing is said beyond.
yes. Yes, therefore, not in my written submission, I will say, if there is no joint trial,
According to you, the view that could be tried together is directly not mandatory.
yes,
Is the correct proposal.
yes, it is absolute discretion of the court concern. Absolute discretion. Even the accused cannot make a demand. The accused has got no right. It is too well settled. Accused cannot make a demand that I should be tried with the so and so. He has got no right at all. He cannot make a demand. But as it is pointed out by his lordship, he can make a request. Please kindly jointly try me. But it is a discretion of the court to decide ultimately whether to try jointly or not. So he cannot demand. Similarly, the prosecution can also insist for joint trial. Because it will be beneficial for them to prove the charge against some of the accused. As I pointed out, approver, confession, etc. It will be useful for them. So they may also insist, but it is for the court, taking into account of the relative hardship. 100 witnesses have been already examined. We cannot call all those 100 witnesses again in the very same case. Court may take such a decision, in which case the court will order for separate trial. It is for a court. But the law is to be made clear by this honorable bench, Murad, so far as this Hardeep thing is concerned, this aspect has not been dealt with at all. Murad, third question framed for answering by this honorable court is, what are the guidelines that the competent court must follow while exercising power under section 319 CRPC? Murad, this, whether it is to be joint trial or separate trial, may be clarified more on the question number 3. This is my humble submission. But I was said in my written submission, if there is no joint trial, how to go about? If the court decides that there has to be a joint trial, then I have said, if the trial court decides to have a joint trial, then first trial should be conducted against all the accused, including the existing accused. In such an event, The evidence already recorded is no evidence against the added accused in view of section 273, Section 32 and 33 of the Evidence Act are not applicable. Section, it may also be argued, section 32 and 33 evidence. That is, prima facie, I can say that it is not at all applicable. At the outset, I can say that. Because
together may become redundant in a case, for instance, Patwalia agrees. Mr. Patwalia himself agreed that if an order under 319 is passed and thereafter judgment is pronounced in respect of the accused against whom trial is concluded, then this could be tried together become redundant.
yes,
It's not real.
see, practically, we have to wait because to take a decision whether to have a joint trial or not, you have to wait. Judgment should not be pronounced in the first case. You have to wait. Because otherwise this will be detrimental to the prosecution.
No, but you began by saying that suppose there is a 319 order passed. The trial is concluded, judgment not pronounced, 319 order is passed. That 319 order is stayed. If 319 order is stayed, then no judgment can be pronounced in the first.
Yes, Manoj, suppose when
You today morning you said that separately judgment can be pronounced.
no, judgment cannot be pronounced. What I say is, Manoj, judgment, whether judgment can be pronounced, it can be pronounced, awaiting the outcome of the decision under 223. You have to wait. Otherwise, this will be detrimental to the prosecution. Because, Manoj, joint trial may be beneficial for the prosecution.
The 319.
Yes.
Then there is no impediment when he pronouncing the judgment.
No, first case, we have to wait for in the first case, the existing case, judgment should not be pronounced. The trial should be kept pending.
Kept pending.
Yes,
But once an order under 319 is passed,
yes.
and if the court doesn't find that a joint trial is necessary,
Well, 319 order is passed in this case, and therefore this case should be pending.
we are only talking about a proposition.
Proposition only what I am saying.
No,
That
suppose-
in the existing case only, 319 order is part of the existing case.
Yes.
The case should be pending for further proceeding in the very same case. So then only, Manoj, the court, the accused has to appear, his appearance is to be recorded as part of this case. Then, Manoj, copies are to be furnished under 207 in this case only. Then, Manoj, the stage for framing of charge against this man will come later in the very same case. Then at that stage only, Manoj, it is to be decided whether case is to be tried separately.
Only at that stage,
Yes,
court finds that it is not necessary to try them jointly.
yes.
Only then the
Judgment can be pronounced.
judgment would be pronounced.
Yes,
In case of the rest of the case.
yes, Manoj, that is my humble submission.
Nagamuthu.
Yes.
So supposing at the stage before the pronouncement of the judgment, a 319 application is passed.
Yes,
Fine.
yes,
Now let us assume once 319 application is filed, you can't pronounce the judgment.
Yes.
You decide the application,
Yes.
number one.
yes,
Let us assume the application is allowed
yes,
and it should unchallenged.
yes.
Then the next stage will be, the court has to take a decision as to whether a joint trial has to be conducted or individually it has to be. Suppose it.
In between, Manoj, accused is to summon, accused has to appear, we have to comply with the 207, copies are to furnish. So it is possible, provided the first case is pending still.
No. Now supposing the court comes to a conclusion that a joint trial is necessary, as you rightly said, the prosecution may insist.
Yes.
Then whatever has happened to the other accused, main accused, already we will put them as main accused.
Yes,
All the evidence has to be scrapped, is that? Because joint trial means fresh trial along with all the accused.
That evidence cannot be used by the prosecution. It can be used only for the purpose of contradiction. That is
Yes.
not scrapped virtually.
Ah.
It is there on record. Like 161 statement which we never use as evidence, it cannot be used in evidence. That is all. Though it was recorded as evidence, it has become useless now, except for one purpose, to contradict.
All right, the court comes to a conclusion that joint trial is not necessary. Then that can be pronounced and this case can be independently proceeded.
Yes, yes, my lord. In that event, that case, the first case will be decided based on the evidence already recorded.
Yes.
So far as the new case is concerned, my lord, evidence is to be recorded afresh.
Fresh.
All these 100 witnesses are to be examined here in chief. In complaint section 273. In his presence, the evidence is to be recorded. That is, suppose, my lord, let us assume in this way, one person dies.
Yes.
One eyewitness who was examined there, he is the sole eyewitness. He was examined in the first case.
Yes.
He was cross-examined in that case.
Yes.
Now when the second case comes up, he dies. He cannot be examined.
Yes.
Then what to do, my lord? Whether that evidence can be used here?
Yes.
No, under section 33 also it can't be used.
It's gone.
Gone. He is entitled for acquittal in such an
For
event.
his luck, he should die.
Or killed.
No, then you, in fact, you are not, then 319(4)(a),
Yes.
319(4)(a), you are actually making it vocious.
My lord, with respect, my lord, the procedure is in 319(4) after 319(1). Kindly see, my lord, before 4.
4)(a), that's what I
One,
say.
my lord, may kindly see
4)(a),
one line.
Actually, witnesses are examined
Yes.
only against such person.
Yes, my lord, may kindly have one line before 319(4).
It can't be, suppose the whole evidence recorded earlier against the other accused is washed away.
Yes.
Or the 319(4)(a)
Please.
requires evidence to be recorded
My lord, kindly
only
have-
against such person, then there is no evidence against the other accused.
My lord, may kindly have one line before 319(4). I can
It will
read.
happen. Your Honor, kindly, practically, Your Honor, kindly approach.
No, practice. See,
Yes.
the act contemplates this. 319(4)
First line.
actually talks about a case proceeding against a person under subsection.
Yes.
Yes.
So,
Therefore, where the court proceeds against any person under subsection 1,
Yes.
under subsection 1 presupposes where the court comes to the conclusion that they could be tried together. Even in such a case, the proceedings in respect of such person shall be commenced against such person, in respect of such person shall be commenced afresh and witnesses
Yes,
be
ma'am.
heard. To say that once 319 is allowed, all 100 witnesses will be recalled, fine. But they will be examined
Not
only
recalled,
in so far,
examined afresh.
examined afresh, only in so far as the role relating to the 319 accused, not in relation to the role against the other accused. That can't be the
Well, it is not possible practically, I say.
practical.
Practically, I say. Well, there can't be two sets of evidence in a given case. One set of
No, it is one composite evidence. That is why the evidence recorded earlier and the evidence recorded later. It is like recalling and.
No, put the court, while delivering judgment, put the court, rely on the 100 witnesses already examined.
No, it is like recalling. That's all. 311. Suppose 311 had been allowed.
No, it can't be recalled because the reason is, those witnesses cannot be recalled by the newly added accused for the purpose of cross-examination. That is my humble submission. Reason is this.
Point is, once you say the moment a 319 order is passed,
Yes.
the whole thing is thrown open even for the other accused.
Yes.
Will be a very, very boring proposition because then no trial can see.
No, that is the reason why I say there is alternative. If this will result in so much of hardship, have a separate trial.
Separate trial.
Separate trial.
Pronounce the judgment on in respect of others.
Yes.
Yes.
Good. Yeah, otherwise what will happen? You are not kindly see.
Once it is accepted that there can be a separate trial,
Yes.
there is no necessity for 319(4)(a) to say against such person.
Yes.
And with reference to subsection 1. This is
Not
actually with
this
reference to
can't be interpreted in such a way, you not may kindly consider this. There are 100 witnesses already examined. This accused, newly added accused is not going to cross-examine them because it is no evidence so far as he is concerned. 273 is a bar. Now, some more witnesses are examined against him. Now, what will happen? There will be ultimately two sets of evidences. One set of evidence against already existing accused, one set of evidence against the present accused. Is it contemplated CRPC? No. It can't be. Therefore, my lord, the evidence should be common against all the accused. My lord, if there is joint trial, the evidence should be common. My lord, the suppose one answer is elicited during cross-examination by one accused. Can we say, no, that was elicited by him, therefore it is not binding on me? No, it is evidence.
No, that becomes a matter of appreciation. Can't
Yes.
say that the whole
Because appreciation cannot be taken read in isolation from the evidence. Because the evidence is to be one and the same. Because evidence recorded in a case is common against all. There can't be one set of evidence against one set of people and another set of evidence against other people. Because 311 is not applicable.
Suppose each one has got a role.
Cognizance of the offence upon which the inquiry or trial will commence.
No, that is because of the same transaction. See, he is found to be, see, what is inquired into.
I'm actually one with what your lordship is saying here. In fact, I have a slightly different path here. I agree with what is falling from your
In
lordship.
fact, 319,
No,
by the
let my
inquiry.
elder friend explain to me. No, I want to know it. No, please, let us understand what the law is. Let's, in a given case, 100 witnesses have already been examined. Now, no more witness is going to be examined now. No more witness. Can you use that evidence against me? No, you can't use.
No,
Then how will you convict me?
no, it is not used against you. That is the reason why, in so far as you, again, in respect of such person, according to you, has got no meaning.
No, it was some interpretation. Not interpretation used to be workable. My humble submission is, 100 witnesses have already spoken. All are exhausted.
Correct.
No more witness.
You are right.
No more witness.
Is a-
Now, what can I do? I am the newly added accused.
If the words could be tried together, could be interpreted to mean that is only directory and not mandatory, then we will have to apply an interpretation to clause A of subsection 4, so that there is the whole thing gives a comprehensive meaning.
Let me try to understand, brother. 100 witnesses have been already examined, all exhausted. No more witness. Now I am added as accused. How to go about in respect of recording evidence now?
No, for his role, you examine.
For me, as against me.
That's all.
As against me, already witnesses have spoken. That's the reason why I have been summoned under 319. Now that evidence is no evidence against me. Now trial has to afresh go.
That evidence is no evidence against me against you because they were not examined in your presence.
Yes.
Now they have to be examined in your presence.
Yes.
You get an opportunity.
How to examine?
If what you say is accepted,
Chief examiner.
all other accused also will again have an opportunity to cross-examine. The whole thing is completely thrown open.
But cross-examination will not close anything. Cross-examination is the right at any number of times one can have opportunity to cross-examine. But my humble, this predicament you have to kindly consider. But I come to the court, I say, all witnesses have been examined in my absence. There is joint trial. What shall I do now? You can't use that evidence against me. I do not want to recall any witness. You can't use that evidence against me. Then I am entitled for acquittal. The whole exercise under 390 will go waste. Therefore, my lords, it is to be interpreted to say that when you decide to have a joint trial, there has to be one single trial. There can be two trials, there can be two sets of evidence.
No, it is a single trial where witnesses are again examined. That's all. It is not that it is a single trial.
In the illustration,
single trial.
in the illustration which I gave, where is the question of examining again? But may I ask the question to myself? 100 witnesses already exhausted. I am not recalling any witness. I stand.
Prosecution
What is the
can call witness, there's not need, prosecution will request because prosecution has to prove its case.
311.
No, when there is a separate trial, are concerned, already record evidence may be sufficient. But we have to ease down the situation of trial courts. We cannot make the provisions very hard for them to follow by interpreting. So this is the only way we have to make the things very easy and workable for the trial courts. If there is joint trial, see, that is the reason why we are going to tell the court, don't have joint trial. Because 100 witnesses have been examined. This will be an unnecessary hardship. That is why I submitted already. The other accused have already cross-examined 100 witnesses. Now we are not asking them to again cross-examine these 100 witnesses. Will be an unnecessary hardship. It will not be fair. It's not a fair trial. This is a ground to have a separate trial. This is a ground. This will cause unnecessary hardship. 100 witnesses have been examined.
And who knows, they may have included some admissions in the cross-examination. Everything will be blown away.
Yes. Yes. Therefore,
Best thing is to
Have a separate trial.
separate trial.
suppose the witness now turns hostile. So what can we do for that?
Can't help.
The witness now turns hostile in the second trial.
Yeah.
So the witness on whose evidence 319 was ordered now turns hostile in the first trial. We can't help. That is what is the conviction rate that we are recording in this country? 7-8%. There is
5%.
5%. There is murder. He has not committed suicide. Man died because somebody killed him. Who is that somebody? What is the system? We say that the prosecution has not.
Anyway, still they are punished, Nagamuthu,
Yes.
for the simple reason. Process itself is punishment now in our country.
But it is
They are
extra.
still punished. They may be acquitted ultimately, but they would have suffered, for 10-15 years.
This is extra constitutional punishment. IPC doesn't say that this is a punishment.
Exactly.
Practically, there are a lot of. The last point that I fully agree with Mr. Chakwadia. He said, Manoj, that in the given case, 319 petitions were separated from the main case. It was treated as an independent case. There was an order passed. But that, in my humble submission of him, this is wrong. Well, this should be part of the main case as a submitted. Order is to be passed in that case as an interim order. Then, in that case only copies are to be furnished. In that case only, decision is to be taken whether there is to be joint trial or not. But if it is an independent proceeding, then the evidence in another case, that becomes an extra case now. It's another case. That cannot be considered. So that itself is wrong. It is my humble submission. The trial court ought not to have separated the 390 proceeding as a separate proceeding and decided as an independent proceeding. That is not correct, Murad. I also said in my.
But Nagamuthu, see, on the main SC, they called Sessions case.
Yes.
It's disposed of. Then how do you continue with the same number? Session case 2, something like cricketers, so 2. Something.
That is why it should not be disposed of.
2A, 2B, 2C.
Something like that.
Plus, that is why it should not be disposed of. It should be a sessions case. This should be a miscellaneous application in the sessions case.
Okay.
Part of the same proceeding. It cannot be a separate proceeding. It can't be an independent proceeding. But in this case, Murad, from
Yes, that's
they are separated. That is wrong. So far, a third person is
There's a
concerned.
query which my lords have put, my lord. They are separate session cases in the same FIR. In case the accuser absconding and subsequent charge sheet is filed, you have sessions case maybe 5 in the first one and maybe 20 in the second one. That is the practice which is being followed. It need not be the same sessions case. So if supposing there are 10
It need not be. Here also where for the other separated accused,
yes,
there is a separate sessions number.
yes.
But so far as this application is concerned, is not in that sessions case number, it is in this
It's a
session.
miscellaneous, it is a
That is where
miscellaneous-
the difference
It's a
is.
miscellaneous thing.
Lord,
But as
when
far
the
as
accused
trial
will
is
appear,
concerned,
when
there
the
can be
accused will
two
appear,
sessions
my lord, then the number.
Maybe while trying separately, maybe if, then that miscellaneous case may be a fresh number, such
Yes.
cases may have to be.
Please.
Purpose of deciding the 319 application, nothing to do with the sessions case. It's only for the purpose of deciding the 319 application that a separate number is given.
No, that miscellaneous should be in a sessions.
Yes.
It may be, but.
It is
but
separately, my lord, kept.
Like
And then
supposing,
you
Bail
have
application.
a miscellaneous case, decide and then say now this becomes sessions. In a sessions
My lord,
case, the
right.
miscellaneous application.
Originally, the application
like
was in
getting
that
custody of goods, my lord. For custody of goods, you have a separate application. But it is in the same case, but the application is separate. It has nothing to do with the main trial. When you apply either in 451, 452 or 457 for getting custody of goods, the application is numbered separately.
No, that is because there is no right to the accused there. You just get back your things.
Yes, but you have to apply in
You
that
get
case.
back
You are
your
applying in the
things from
case
court.
that it is not part of the session case, it's a part of a miscellaneous application which is made.
If it is a miscellaneous application, in A case, you can consider the evidence in A case. If it is a miscellaneous application B case, you can consider the evidence in B case. If it is neither in A case nor in B case, what is the evidence that you are going to consider?
The proof of the pudding is in the
What is the evidence?
Till 31st, the application is marked in that session trial. All orders are on the record.
But it was separated.
It is only after 31st that it becomes sort of orphaned.
Evidence of the
Because-
sessions case has to be considered.
28-9
That's all about-
Yes, until
28-9.
it is mentioned in that section trial. Then after 28th, it just becomes orphaned from that trial, which is not possible.
But it could have been considered before the judgment was rendered in this case.
Can-
This application could have been considered and a separate trial could have been ordered also.
Correct.
Yes.
Now, the whole only thing is it has been considered after the first case has been disposed of.
Correct. That's the-
If this application treated as part of the second case, then evidence is to be recorded in that case, then only decision can be taken. Now there is no evidence in the case. Evidence is only in A case. So this should form part of this case. It's a miscellaneous application.
No, but the trial could have been separated also.
Yes. Then only, my lord, so the occasion to decide where there will be joint trial, etc., will come.
Yes, Nagamu.
So lastly, my lord, my friend was referring to Jogendra Yadav, my lord, state of Bihar. That is the case, my lord. I do not know whether it will be appropriate to raise that issue in this case, my lord. That was a case where this honorable two judgments were stated that before invoking section 319, before passing an order, you have to afford opportunity to the accused, proposed accused. He has to appear, he has to say that there is no evidence against me, and there is no justification to pass an order under 319, then only when an order can be passed. The judgment also further say, on his appearance, moral copies will be furnished, and he is not entitled for discharge. That judgment, but I got my own reservation about that judgment, but I raised it, his lordship left it open to be raised in some other case, and before the two judgments I raised it, his lordship left it open to be decided in some other case. So that is also that Jogendra Yadav also will not make.
That judgment may not be relevant here.
I leave.
May not be relevant.
That reference was made by my friend Manada.
Anyway, that may not be relevant for us.
Great, I am very grateful Manada for having given me this wonderful opportunity.
Thank you so
Very
much.
grateful.
Thank you.
Grateful to all of you.
Just, I think one of you, somebody, you wanted to make brief, very brief. Very brief. Very brief.
Just
5 minutes.